Welcome to Miller-Mayer's webinar today on how to navigate the H-1B visa lottery and other visa options. I'm Steve Allaire, and I'll be moderating this webinar. I'm delighted to be here today with my two colleagues, Hillary Frazier. Hi, Hillary.
Hello, everyone. Thank you for tuning into our webinar.
And Sandra Bruno.
Hi, everyone.
A little bit about Miller-Mayer. We have over 25 years of experience guiding U.S. businesses on all aspects of immigration law. And there you see our great features. And on the next slide, you can see individual photos of us. I'll let you guess which one I am. We've got a lot to cover today, so let's get you right to an overview of what we'll be talking about. We'll be focusing on the H-1B temporary work visa. And that is one part of our very complicated and large immigration system. It is the workhorse for professionals who want to work temporarily in the United States. So we'll be focusing a lot on that, but toward the end of the webinar, we'll also be talking about other possible visa options for people who don't get an H-1B visa. So we'll start with basics. We'll talk about this so-called H-1B lottery. We'll talk about what happens after you apply and options if you lose the lottery. And at the very end, we'll give you some bonus slides if you stick around to the very end. We will email our presentation to everyone, including the bonus slides afterwards. So you don't have to take notes. We do encourage you to submit questions through the chat feature as we go along. We'll either answer them as we receive them to be able to help you if they tie into what we're talking about, or we'll save them toward the end. We hope to reserve about 15 to 20 minutes at the very end to answer your questions. So with that, let's start right away and go into the basics. Sandra, we keep talking about H-1B. Where does that lingo come from, H-1B, and what is an H-1B visa?
So the H-1B visa is the most common type of temporary work visas in the United States. It does require an employer to sponsor the foreign national, so keep that in mind. The one thing that is really good about the H-1B visa is that there is no requirement for the employer to engage in advertisement or recruitment or to give preference to American workers. Now, the H-1B visa is limited to those foreign nationals who have at least a bachelor's degree or higher in a specific field. So the position must match that degree that the foreign national holds.
So if I graduate from Cornell, I can't get an H-1B to flip hamburgers in McDonald's?
Probably not. We'll talk about this a little bit later during our presentation, but there does have to be a link between the duties and the degree that the individual holds. The maximum amount of time that an individual can get is limited to 6 years. There are some exceptions to that rule, however. For example, those individuals that have started the green card process prior to the end of their 5th year, they may get extensions past 6 years. And individuals as well who travel and move abroad for at least a year, if they come back, they can also get a new 6-year period. Am I missing something else? Well, like I said, this is the most common type of work visa. It sounds great. A lot of people want it. The problem is that, there's not enough visas available. Unfortunately, there's a limited number of these that can be issued, and we'll go into more detail a little bit later on that.
Okay. And Sandra, every part of immigration law has its own lingo. What are some of the key terms to talk about when we come to H-1Bs?
Sure. So a CAP subject is something that you're going to hear often, especially right now that we're in the season, right, for filing these type of petitions. And being CAP subject simply refers to an employer who is not a university or a not-for-profit affiliate of a university. Then there are also the CAP exempt companies, and those are employers who are, they're a university or they're an affiliate, a not-for-profit affiliate of a university. Another common term that you'll hear us use is an RFE. Hopefully you will never see an RFE. And it stands for a request for evidence. It's a document that the government agency, the immigration agency, issues after they have reviewed a file, such as an H-1B petition, and they're not satisfied on some aspect of the petition. And so what they do is they write up a notice saying, hey, we need more information on this aspect, or we're not quite sure what you mean by this. And so they'll issue that and ask for specific information that they're looking for in order for them to make a final decision on the petition. The other one is the LCA, and that stands for Labor Condition Application. That's a form that the employer, the one who will be petitioning for the foreign national, has to file with the Department of Labor. And they're basically pledging that they're going to be paying the employee a certain wage for the position itself. ONET, that is the Department of Labor's encyclopedia of occupations. It has a lot of really good information. For example, the education requirements for position, typical duties are associated to a position, so definitely useful when preparing an H-1B petition. And the I-129, that's the actual form that we use to file an H-1B petition on behalf of an employer.
So we've been talking about this so-called cap when it comes to H-1Bs. Why don't you tell us a little bit more about what that is and to whom it applies?
Sure. So a cap is a quota. It's a numerical limitation on the annual supply of H-1B visas for certain employers. And those employers are the cap subject employers, the ones who are not universities, and neither are they not-for-profits affiliated with the university. So if you look at the graphic at the bottom of this slide, you can see how the quota is broken down. It's 65,000 visas, H-1B visas, for bachelor's degree holders, meaning jobs that require a bachelor's degree and the foreign national holds a bachelor's degree in a matching field, plus a separate 20,000 for those foreign national students who have U.S. master's degrees or higher. Altogether, then, we've got about 85,000 H-1B visas available for all of the employers in the United States who happen to be not universities, and neither are they not-for-profits affiliated with the university. So there's about up to 85,000. There's a small cutout for Chile and Singaporean treaty visas. Now, H-1B visa petitions filed by universities are cap exempt, meaning there's an unlimited supply. There is no quota whatsoever. They can apply any time of year, and as long as they meet the qualifications for the visa, there's no race or lottery.
So this is per fiscal year, and the federal fiscal year begins October 1, and under the immigration regulations, employers can file petitions up to 6 months in advance. So if you go back 6 months from October 1, that's April 1. So that's when all the employers want to file their H-1B petitions. So tell us a little bit more, Hillary, about how this H-1B lottery in the first week of April actually works.
Right. So the April 1st is not an April Fool's Day, kind of a joke. It's quite serious that in order to claim this limited supply of up to 85,000 visas available per fiscal year, employers want to be first to file. So first to file, first to get a chance at claiming one of these visas. Because so many people file on the same day, April 1st or April 2nd or April 3rd, the immigration agency holds a lottery saying we will receive H-1B filings from cap subject employers for a whole week, a business week. And at the end of that week, we will stop receiving cap subject H-1B filings for the whole rest of the fiscal year. But we receive in 1 week many more applications than the 85,000 can satisfy. And so therefore we will do a lottery. We will do a random computer-generated lottery of all of the FedEx packages that wind up in the immigration service centers. And we will select out slightly more than 85,000 and then subject them to a review or an adjudication. So that's what we mean when we say lottery. And receiving a receipt from the immigration agency saying, we selected your petition out of all those received in the first week of April is what we mean by winning the lottery. It doesn't mean that the H-1B petition will be approved. It just means that the company and the foreign national employee have a chance at getting an approval. And so losing the lottery means no receipt is received.
Okay, so the next slide here talks about how long it's taken over various years to actually go through the lottery system. And you see it depends a lot on the economy. Back in 2009, for example, when we had a recession, there was not really a lottery. It took 9 months out of the 12 months for the H-1B cap to be reached. But since 2013, there have always been more employers than available slots, and that's why we have the first week of April being considered a lottery. Let's turn now to preparing for this year's lottery, and let's start, Sandra, by talking about what happened in last year's lottery.
Sure. So last year we saw 199,000 applications filed that in the first week of April. Now I know that sounds like a lot, and it is, of course, right? Because there's only so many that can be issued. But the year before it, there were about 230,000 applications that were filed. So it's a little bit, gave individuals who filed last year a higher chance of being selected in the lottery. Still, I totally, acknowledge that it's not enough given the high demand we do see. Now, of course, those who have a master's degree, they do have a higher chance of being selected in the lottery, and that's simply because what USCIS does is they do the master's lottery first, and so those that are not selected in that lottery will then be sent to the general pool of the 65,000.
So they essentially get 2 bites at the apple.
Exactly, and so they do sometimes, you'll see that they have a higher chance of being selected in the lottery. Now, just because you were selected, and I know Hillary just mentioned this, the government will choose more than the number of visas that they can issue, and that's because they know that some of them are going to be denied. Some of those, the companies are going to withdraw their petition, or in some cases, the foreign national decides that they don't want to come work for that particular company, and so they simply won't use a visa number. Now, something else that we saw this past year is a lot more RFPs. There were multiple RFPs issued for some cases. A lot of the RFPs were very long. And we'll go into a little bit more detail on what some of those RFPs that were common this past year. There were also very long processing times. I know we are still seeing approvals on cases that we filed last year. I think there are still some cases that are pending. So definitely expect a long processing time for these cases. And unfortunately, I think officers this past year are now reviewing these petitions, and the way I see it is they're looking at these petitions, looking for a reason to issue an RFP or deny it. And so they're looking at every little detail of the petition, for example, the wage level, the job requirements, the description of the position, the location, has the student been maintained his or her status. And so they're really looking closely at each of these petitions. So, we do need to make sure that we're very careful in preparing these. There are also, of course, travel problems. We saw that since the beginning of last year with the travel ban. And so there's definitely delays in the security clearances and refusals of visas. And of course, finally, I think we've seen this a lot in the news, and there's a lot more worksite visits and audits. Just to confirm that basically the employer, that everything is as it was described in the H-1B petition.
So Sandra, has USCIS mentioned that there are going to be any changes to this year's H-1B lottery?
Yeah, so about a month ago, they finally said, there was a lot of speculation about possible changes for this year, for this year's cap season, but they said that there will be no changes to the way that they process and they accept petitions. So we at least know that much. Unfortunately, there are still a lot of uncertainties with the process. Just last year, after the cap season was over, on April 18th, the president signed this Buy American, Hire American executive order. The goal of this executive order is to create higher wages and employment rates for U.S. workers. And they mean to accomplish this by rigorously enforcing and administering our immigration laws. And so again, with what I just said, I think the officers are really trying to carry out this executive order by looking at every detail of the H-1B petition and raising as many issues as they can in RFPs. It's also noteworthy that the executive order specifically mentions H-1B, so I think we do know that they are being targeted. And finally, there's been changes in the H-1B bureaucracy, which we'll go into more detail.
Great. So some other things that have not happened this year, people have heard about H-1B in the newspapers, because there is a lot of talk about changes. But so far, for example, Congress has not instituted any changes to the H-1B program. They're not going to prioritize jobs based on their wages or other issues, at least for this year. As we'll talk about later, certain spouses who are in what is called H-4 status can get work authorization, which is technically known as employment authorization document. That exists now, and there have been talk about repealing that special privilege, but that has not happened. Premium processing will be suspended for CAP H-1Bs, but we may resume premium processing before October 1, like we did last year. So we will see. So Hillary, luckily there's been no legislative changes, but tell us a little bit more about the H-1B bureaucracy and how that's changed the whole landscape.
Sure. So I think as lawyers, as Sandra pointed out, we have seen these changes coming for more than a year now, but it's hard to point to an authority that say, why is this happening? Except for the executive order that does mention H-1B petitions and does seek to protect American workers. So instead of taking it from lawyers, you can rely on the general press as well, which has analyzed the change as a change not to the law, but to the bureaucracy. And this Quartz Media article called "Trump is Quietly Swamping Visa Applicants in Extra Paperwork" concludes that obtaining an H-1 visa has already quietly become more cumbersome since Donald Trump became president, not through any change in the law, but through bureaucracy. And that pretty well sums up what we are seeing, particularly with a spike in RFEs.
So this next slide here talks about that, and we see here it really has spiked. And it's been 85,000 requests for evidence that the immigration agency sent out last year, and that's more than 45% above the same period in 2016. So Sandra, what does this mean in terms of dealing with H-1Bs?
A lot of problems. So it's just generally more difficult because a lot of more issues have been coming up. One of them is that past adjudications that were successful are no longer being deemed, are given deference. So it's not, they're just not as important as what USCIS is saying. They're looking for higher wages as well. Level 1 entry-level wages have been problematic this past year. And this also means that attorneys and anyone really that's preparing an H-1B petition has to be very careful, making sure that there are no errors or inconsistencies in the documents. We have to be very careful when including the job description, the duties, the qualifications of the individual as well. Traveling as well can be problematic. Again, there's a travel ban, there's administrative processing issues, and there's security clearances. So a lot going on there. So you do have to be careful when considering travel. I mentioned earlier how the government agency is just taking a long time to make decisions on these petitions, and so I think that's creating a lot of problems for companies and employees who would like to be able to know what's going to happen to their case. Are they going to be able to start working when? And so that just makes it very difficult to plan ahead.
Great. So Sandra, you mentioned this level 1 wage. Why don't you tell us a little bit more by what you mean by that and why it's causing some problems?
Sure. So the two type of RFPs that we saw a lot this past year, one is a level 1 wage and the other one is a specialty occupation. Now the specialty occupation has been coming up a lot in recent years, but I think they're looking at it even more closely now. Specialty occupation, like we talked a little bit about this before, has to be a correlation between what the individual has a degree in and what the duties of the position are. And so the duties of the position should basically require knowledge that is typically acquired in at least a bachelor's degree or higher in a specific field. So a specialty occupation RFP, what the agency was claiming is that according to their to the ONET directory that they have, a bachelor's degree or higher in a specific field is not a minimum requirement in order to enter that profession. So they're simply questioning well, anyone else could come and take this position. They don't need a degree, a bachelor's degree in this particular field. That was one of the RFPs that we saw a lot. The other one is a level 1 wage. And if you take a look at the next slide, this might help explain it a little bit better. So what is a level 1 wage, right? And so this page is available online. It's the Foreign Labor Certification Data Center. You can go on there and use the search wizard. You can put in for any position that you're interested in, or if you just want to check what does the government think should be paid to an individual, you could look it up by putting in where the position is based. So here we have the example of Ithaca, New York, and we would put in the position, which would be a graphic designer. And then they will tell you then, according to the government, a level 1 or entry level position would probably pay about $33,925. That's what they would require the company to pay a graphic designer who is just taking on the entry level position. Then there's a level 2, which is a little bit higher. Usually means there's more responsibility associated to that position. And then you have the level 3 and level 4. So in the level 1 RFPs, the government was claiming that if the employer is only offering a level 1 wage, then that simply can't be a specialty occupation, because a specialty occupation often requires complex duties. And so an entry-level job couldn't be that.
Great. Let's go on to the next slide. And Hillary, let's talk a little bit more about how you determine what is a specialty occupation for H-1B purposes.
Right. This point really can't be stressed enough with H-1Bs, that the immigration agency looks first to the Department of Labor indexes, one of which is this ONET. And at the bottom of this graphic, under the heading Job Zone, you can see that graphic designers in the ONET are defined as Job Zone 4, considerable preparation needed, and under that, education. Most of these occupations require a 4 years bachelor's degree, but some do not. So this gives the agency some wiggle room to claim that the particular position in the H-1B petition does not require a bachelor's degree. But what I want to say here as well is there are other sections of the ONET that we couldn't fit on this slide that also describe what type of educational preparation is needed to be a graphic designer, for example. And if the ONET says that a degree in many different types of fields may suffice as preparation for graphic designer, then that's not necessarily an H-1B specialty occupation. Because as Sandra said, the position has to require a bachelor's degree in a specific field. And therefore, someone with a bachelor's degree in a different field may not be eligible. And if any kind of bachelor's degree works to be qualified for this position, then it's not H-1B eligible.
So Hillary, what are some strategies to handle these kinds of requests for evidence?
Okay, so one way is to look at the wage levels that the index that Sandra was showing and make sure you're paying level 2 or higher. Avoid level 1 if you can. If you can't avoid level 1 in small companies in smaller towns, perhaps pay less due to the cost of living, then another option is to file with the Labor Department 2 different LCAs, one using the level 1 wage and another using the level 2 wage. That prepares you for an RFE. In case the immigration agency challenges on the level 1 wage, you are already prepared. You raise the salary after April 1st and in response to the RFE, and show that you have made the preliminary filing at that level 2 wage. Another thing we sometimes do is look for a different occupational code in the ONET that has a lower associated wage scale. So a graphic designer job might be a commercial artist occupation, or in digital media, it might be a digital designer. So we can look for an occupational code that has a lower wage scale. We can also, of course, just challenge the logic and the legal interpretation used in the RFE. And with that, we were successful last year on many of these types of RFEs that we received. One key caveat, one key warning is don't overdo it in your job description. because sometimes the agency, the immigration agency, will say, okay, we agree with you that a level 1 wage is okay in this instance, and the job is a specialty occupation. But look, your employer required a master's degree when the ONET code only requires a bachelor's degree. Therefore, you should be paying a level 2. So if the employer stocks the job requirements with requirements that are higher than what is equivalent to a level 1 wage position, that can actually invite an RFE and a denial. And there were actually 2 cases that came down just last month where this was exactly the finding. So your final strategy is, of course, appealing your denial to the AAO, the Administrative Appeals Office, and you may get a decision before the following April. And if your decision is positive, then of course you don't have to apply in the CAP lottery again. This year, 1 case came down and denied a financial analyst, an investment banker in New York, for just that reason. The employer had loaded the job description with requirements that made it not a level 1 wage appropriate. And another case where the employer succeeded in gaining approval with a level 1 wage position because the employer was able to demonstrate that their position truly was entry level and the ONET code supported it.
So, Sandra, we have a question about F1 curricular practical training from one of our listeners, and that ties into the very next slide. So why don't you talk about that, and what are some of the issues there to watch out for?
Yeah, so this year, another thing that immigration also brought up is the use of OPT and CPT. So in particular, they were focusing and targeting those petitions where a foreign national had completed his or her OPT, so under 12 months. Then they continued to work for that same employer by enrolling in another institution that immediately authorized CPT. Therefore, they were continuing to work for that same employer, but now instead of OPT, they were using CPT. What the immigration agency was claiming is that they had failed to maintain valid F1 status. So they were issuing RFEs on that. So definitely our advice is to avoid CPT in a master's program if it's simply intended to extend the OPT period for the individual. Also, you know, the immigration agency, they could deny the change of status for failure to maintain F1 status, but the individual could still consular process abroad. So that's something that you could also choose instead of requesting a change of status, simply checking consular processing.
So Sandra, say I'm a person who wants to get an H-1B. What advice do you have for me on how to maximize my chances of winning the H-1B lottery this year?
There's a couple of things that you could do. You know, one company is not allowed to file multiple petitions on behalf of one individual. However, an individual can get multiple companies to file a petition for him or her. So definitely, if you find multiple jobs and they are all willing to sponsor you for an H-1B, that's totally you know, doable. You can apply through more than one employer. If you have a master's degree that is going to be issued or completed before April 1, then you would fall under that master's cap, and so that would be that would give you a little bit of an added boost in lottery. Make sure that, you know, like I said before, that what the classes that you took, the degree, they match nicely with the duties of the proposed position. Also, for those individuals who you know, are applying for the H-1B, I always encourage people to make sure to apply for OPT or STEM OPT if they're eligible. You don't lose anything by applying for that, and it gives you a little bit of a safety in case the H-1B is not selected. Also, if your OPT is valid past October 1st, then sometimes we recommend choosing consular notification so that instead of having the status automatically changed on October 1st, the individual can go abroad and pick up that H-1B visa at the end of the OPT period. Of course, if your OPT expires before October 1st, then we would recommend selecting change of status so that you could continue working from the end of your OPT period until October 1st. Be careful with your level 1 wage, like we said before.
Okay, let's move on and say, okay, now that we've applied, let's assume that I'm lucky and I'm actually selected in the lottery. Now I'm waiting, and it's June, July, August, And my question is, Hillary, can I travel?
Oh, we feel sorry for the students who are stuck in the United States by long immigration adjudications, but we hate this question and we want everyone to stay put in the U.S. However, some travel accepting a risk can be undertaken so long as the H-1B petition has already been approved, and that may require premium processing. There's a chance that USCIS will restore premium processing for CAP cases after this April lottery, but before October 1st. If so, long pending petitions could be accelerated, an H-1B approval could be gained, and an F student could travel and re-enter as an F. We caution against it though, and if you are considering that, you might want to consult with an immigration attorney.
Another question that comes up, what about changing jobs?
Also risky, and in the past has worked, but as we've all been saying, what has worked in the past may not work this year. So avoid changing jobs. Or better yet, start the job you'd like to leave on October 1st when your H-1B becomes valid, and work at it for a couple of months and then change jobs. Changing jobs before October 1st could work. It's called portability. It did work in the past. After October 1st, in other words, never starting with the employer with whom you won the lottery after October 1st and then trying to file a change of employer petition is probably not a good idea.
Okay, and the next slide says, how am I going to know if I was not chosen? You can read the slide there. It's pretty self-explanatory. And let's move on to people who have lost the lottery and what their options are. So there are a fair number of options. It really is an individualized fact and circumstances analysis as to what will work for one particular individual. So for example, if they have STEM OPT that's valid for 3 years, they may be able to continue working on that. They may want to go back to school. They may want to see what their spouse's work options are and see if they can get a work permit through their spouse. Or we'll talk about other options like other visa categories. So all of these things on this slide do sort of get into more depth on future slides. Let me go immediately to that. And let's talk first about other H-1B options. So not all hope is lost if I lose the H-1B lottery, correct, Hillary?
Correct. And so come May 2018, if you are an H-1B applicant in the lottery and you don't get a receipt, then you need to start looking at other options. And your best option is actually a CAP-exempt H-1B employer. So if you can quickly put together a job, even a part-time job at a university, that's a great option. Why? Well, there's no lottery for universities. You will probably gain approval of that H-1B, and here's an added bonus. Once you have a university H in place, you can do what's called a concurrent H-1B and get your private employer who lost the lottery to sponsor you for a concurrent, meaning at the same time, 2 jobs at once, H-1B, and that second H-1B is CAP exempt. So concurrent H-1Bs, starting first with an academic H-1B, are one strategy. Another strategy is your private employer can employ you, pay you, sponsor you for an H-1B if your work site is on a university campus. If that is true, for example, Microsoft is paying a researcher to work at Cornell's computer science department, that is considered a CAP-exempt H-1B. A third option that is pretty much limited to researchers and doctors who work at teaching hospitals is the affiliated not-for-profit with a university. A new option that came into being about a year ago is the local or state research organization. And to be honest, we don't know really what that means. The law prior to last year allowed CAP-exempt H-1Bs for federal research organizations, and not many of those were filed. The law has been expanded to cover local state research organizations as well, and we just don't have enough practical experience with that to know if how it's going to work. One other option is if you are an H1 pair, couple, that's the word I want. If you're an H1 couple, meaning your spouse has an H1, but you fail at the lottery, then if your spouse is already partway through the green card process and holds an approved I-140, that's the green card petition, then you might change from F1 to H4, that's the spouse of an H1, and be able to get a work permit. So that's a good option for someone whose spouse is an H1 and is already partway through the green card process.
Let's talk about other F1 options, Hillary. What are those very quickly?
Okay, so you can return to campus. You can enroll in a new degree program with on-campus or curricular practical training option available to you after 2 semesters. If you're in a non-degree program, of course you have F status, but you don't get any work authorization when you finish the program. If you get a degree at a higher level, in other words, you completed a master's, you didn't win the lottery, you completed a bachelor's, you didn't win the lottery, and you go back for a master's degree, you can receive a whole nother year of OPT. And in some cases, if you are in a science, technology, engineering, or math field of study, a STEM field, then you can get an additional 3 years of OPT. One thing to be careful of is that schools that are for-profit schools do not count for purposes of the U.S. master's degree special pool of 20,000 in the H-1B lottery.
Let's talk about other temporary work visas. Some of these have advantages because they don't have this cap like the H-1B does, and others have certain special conditions which can be good or bad. So let's take a quick look at some of these other visa options. The ones in green are the ones that you want to focus on because they allow people to work. So for example, if you are from a treaty country with the United States, you may be able to enter that way in the E category. If you are an exchange visitor, we'll talk about that on the next slide. If you have an L1 possibility because you work for a multinational company overseas for at least a year in a position of executive manager or person with specialized knowledge, you may be able then to transfer into the United States after a year and avoid the H-1B lottery that way because you come in on an L1. Some of our clients have extraordinary ability, and so they can qualify for an O visa. And if you are a professional from Mexico or Canada, you may qualify for what's called a TN visa category. Sandra, let's talk a little bit about just the D1 option as one example, and how would that work here?
So the J1 visa options are for interns or trainees, right? And an intern would be someone who is currently enrolled in school abroad or who graduated within the past year. Or a trainee is someone who already graduated and has at least 1 year of work experience or has 5 years of work experience in the field in which they propose to come work here in the US. Now, individuals who fall under these two categories can come work for a private company through by working with a J1 program sponsor. And so they're the ones who will sort of help them with providing the information and the documentation for them to come in as a J1 visa holder.
One question that we always get is, what are my chances this year? Are we going to have more people or fewer employers applying for the H-1B lottery this year? And that's really hard to predict. There are a lot of factors. So for example, there's this Deferred Action for Childhood Arrivals program that allows people to work in that category. If that ends on March 5th or later, that could increase the number of people who want to apply for H-1B instead. There has been some talk about the Trump administration taking away the special 3-year work authorization for people who are in science, technology, education, or math. I don't think that's going to happen this year, but that uncertainty may nevertheless mean that more people are interested in the H-1B this year. There's a new high-skilled worker rule, and as Hillary pointed out, certain state and local government research agencies are now cap exempt. And we don't know about IT companies, whether they're going to shy away from the program or not. So there's a lot of uncertainty, and nobody really knows for sure. But with that, let's stop for questions and see what kinds of questions we have. So we had some questions that came in, Nellie, beforehand. Let's first answer those questions since they wrote them beforehand. And let me start with one about, are there going to be more visas available this year than previous years? The simple answer to that is no. Congress has not changed the cap on H-1Bs. It's still 85,000. If your question is really, are my chances better than last year because fewer people will submit applications, We simply don't know. Another question is consular processing, and whether is that going to be difficult or not. And Hillary, what's your answer on that one?
So our webinar audience might not be able to see the question. It says, I'm interested in the consular processing for H-1Bs, as well as traveling back to the country of origin while waiting for the approval of a labor certification. We're not exactly sure what the question is, but about travel. Going back to the home country to get a visa issued is a risky proposition for people of many nationalities now, as well as for people who have extensive travel experience. We have a lot of clients that are getting stuck overseas. So we would advise, if you're planning on traveling overseas in consular processing, consult with an immigration lawyer. But if the question is, I have a green card started, can I still re-enter the United States as an H-1B? The answer is yes. As an H-1B, you're free of the limitation that F-1 students have about not pursuing a green card while you are in F-1. H-1s can pursue a green card at the same time and not have any intent problem.
So Sandra, the next question that came in before the webinar is, if I have a wife, can she work in the United States?
If the question is asking, if the individual has an H-1B and the spouse is an H-4 and that H-4 can work, then the answer is yes. If the I-140, the H-1B holder has an approved I-140.
And that answers one of the chat questions about H-4 spouses and working. And again, as you pointed out, Sandra, the person has to have an I-140 green card petition approved before that can take effect. Hillary, let me ask you the next question. It's got 4 parts, and let me break them down and ask them individually. First, has premium processing been reinstated?
Only for non-lottery cases. So premium processing is not going to be suspended this year unless it's a cap lottery case. For cap lottery cases, there's no premium processing at present.
At present, but as you pointed out earlier, maybe that sometime in the summertime they may reinstate it then. Second, if you do use premium processing, how will you know that you have not been selected through the lottery?
The same way everyone else knows. You don't get an email if you're premium. Well, I mean, this is not a question because there is no premium processing for, So, I mean, the way anyone knows that they haven't been selected is they don't get a receipt, their filing fee check doesn't get cashed, and in June sometime the petition comes back to the employer.
Another question is, can you travel outside the United States during what's known as the cap gap? Why don't you explain what the cap gap is and then talk about traveling during the summertime on cap gap?
Okay, people whose OPT, that means their student work permit, is still valid on April 1st, and that work permit expires before October 1st, but they are lucky and get selected in the H-1B lottery, are able to, by matter of law, by operation of law, continue working after the expiration of their student work permit, their OPT, right up until October 1st, when their H-1 becomes valid, so that there is no gap in employment eligibility. Someone who is cap gap should not travel, basically.
Another question that came in was about architects and whether architects qualify for H-1B. Hillary, you want to talk about that?
Well, architect is an example of a profession where CIS, Immigration Agency, has equivocated a bit on whether the profession, the position requires a bachelor's degree. And the reason they've done that is architecture in the US is a licensed profession, and people have to work for several years before they become eligible for a license. And therefore, they are seeking an H-1B not as an architect, but as a designer or a drafter. And designer and drafter are positions that the Immigration Agency does not always consider professional.
Another question that came in through the chat function is, what occupations should we be worried about that may not be considered specialty occupations? For example, the USCIS rescinded a memo last year saying that computer programmers will inherently qualify for H-1B purposes. What other professions, like architecture that we just mentioned, Hillary, do you think may be problematic for this year's lottery?
Well, last year I think we had a lot of problems with marketers and marketing research analysts, but I think we were successful in overcoming those RFEs. So, and I think a lot of other law firms were too. So I think maybe we're winning this battle, but it is still a battle.
And Sandra, from your experience last year, what are some of the successful cases that you were able to win after overcoming a request for evidence?
So, I mean, the one we saw, there were some engineering positions, which kind of make no sense, but I think we were caught by surprise. And the other one would be someone similar to a marketer, or a public relations individual.
And from my own experience, I chair the Business Immigration Committee for the American Immigration Lawyers Association, and although we didn't have this precise case, one of my committee members mentioned to me that they got a request for evidence for a doctor, which is hard to believe that a doctor does not qualify as a bachelor's degree. But nevertheless, they were successful in overcoming that, but it shows you the extraordinary lengths that USCIS seems to be going to question even obvious jobs. Another question that came in through the chat function is, does a professional degree such as a Juris Doctor degree give a person an advantage among the other U.S. master's degree candidates? Sandra?
No, it doesn't. I mean, they're all basically at the same level. All master's degree and professional degrees are going to be considered the same.
Great. And somebody else asked whether MBA students, do we know how many of them applied for the lottery? Unfortunately, the USCIS does not break that down by occupation in terms of who applied, whatever. It's enough for them to try to figure out the numbers, let alone the occupations there. So, yeah, we answered the one about for-profit university already. So if you have other questions, feel free to email us now through the chat function. We're just looking here. Somebody is typing a question. So I think that we certainly are busier this year in advising our clients about the H-1B process. We're starting earlier than in past years in advising clients how to go through the LCA process with the Department of Labor to make sure that those are obtained as early as possible, particularly if the employer is filing 2 LCAs. It's going to just take longer and be more complex to go through the H-1B process this year than last year. Sandra, did you want to add something?
No, I mean, generally, I think we just have to be very careful. I know I've said this so many times, but I mean, I've just, in my own cases, I have seen how long it is taking to get these decisions finally to come out of USCIS. And, interestingly enough, the 2 cases that Hillary mentioned, the ones that were issued on appeal, I was also surprised at how quickly those came back. So, even considering an appeal, typically I don't like appeals because they can take a long time, and maybe just trying again is something that I would have considered, but it's kind of nice to see that they did take action rather quickly. But again, you also don't want to end up going that route. So I would definitely urge you to prepare, as much as you could from the very beginning so that you can hopefully avoid an RFE or get an approval right away.
And I would add, I think our bonus slides are worth looking at, especially for those other options. If the H-1B lottery is not a success, or even if it is, there are a lot of other good work visa options that the U.S. offers, and people tend to know primarily about H-1B and not the other options. But for example, nationals of certain countries can invest in and start their own mom and pop scale business. So a small business can qualify, a small startup business can qualify for what's called an E-2 visa, and that is described in our bonus slides. Additionally, people tend to think that their best green card option is to get an H-1B and then work towards a green card. That's true in many cases, but sometimes an even better option is to leave the United States and work for an affiliated office of a U.S. multinational company, because executives and managers of foreign affiliates of U.S. companies can transfer to the U.S. in a category called L1, also described in our bonus slides, that has a really fast-track green card route. So sometimes losing is winning, and not getting picked for the lottery can mean exploration of other visa types that are actually very beneficial.
And that's why individuals should have an initial consultation about their individual facts and circumstances. So before they jump to the H-1B, they should explore all their visa options, and an in-depth consultation will advise them on what to do and how to plan for it. Particularly, they should not wait until the spring semester of their senior year of college to think about these things. So many times, if they have a consultation as a sophomore or junior, they can sort of plan when they should use curricular practical training or not, when they should use optional practical training or not, and what other options are there available to them. And that sort of leads into a question that we have that just came in on the chat line. The individual asks, I am applying for optional practical training. I graduated in December and I have a job. Should I tell the employer to start the H-1B application this year because I'm still waiting for my optional practical training work authorization to come in?
I would say definitely yes. Doesn't hurt to ask. And here are the benefits. You can have both. If your employer is willing to sponsor you for an H-1B this April, that petition can be filed in a way, it's called consular processing, that allows you to work your full 12 months of OPT and then leave the United States and go pick up that H-1B. But you will have the certainty, if you are lucky to win this year's April 2018 lottery, that you have an H-1B waiting for you. Second reason is the risk to the employer is not huge. If you are not selected in the lottery, the employer gets back their filing fees. The filing fees for H-1B cap cases are fairly high, about $2,000, and that can be off-putting to employers. But if your petition is not selected, then the filing fees come back to the employer. So you can make your employer feel like it's not a huge investment, and it relieves the high-pressured obligation of filing next year.
Another question that came in concerns labor condition applications and the beginning date. And what is the beginning date for a LCA? And what if the date is before October 1 when the potential H-1B can start? How do you square the circle there, Hillary?
Okay, so yes, that's just a date game that is played with the LCAs. We date all of our LCAs for September 15th, which means we can file them as early as March 15th. Which means that they are valid at the time of requested validity start date of the H-1B, which is October 1st. So filing March 15th allows us to get a certified LCA back before April 1st, and still have that LCA valid for a time period shortly before October 1st.
But there is somewhat of a risk because the Labor Department gets swamped with these LCA requests in March, and so although they'll say they'll turn them around in 7 days, sometimes it takes a little bit longer. So it is sort of playing that, how long can you wait to file the LCA and still make sure it's back in time to be able to file the H-1B petition?
And I mean, you're never going to get the full 3 years in that initial period of an H-1B petition because of the LCA issue. But, you know, keep in mind that you can definitely renew it again, and at the second renewal, you can ask for another 3 years. So don't feel like you're losing out by filing the LCA early because no one is really getting that full 3-year period in H-1B.
Another question that came in is, are multiple H-1B petitions from different employers for the same employee viewed as sketchy, or is it a legitimate path to take? Does the USCIS look at this when they pile through all of the petitions? As long as the different petitions have different federal employer identification numbers, then it is legitimate. The easiest case is where you've got two completely different companies filing petitions for the same individual. Say IBM and Microsoft both want you to work for them, and they're both willing to file H-1B petitions. There, it's clear that that's not a problem at all. It gets a little more in the gray area where you've got affiliated companies, but as long as they have different federal identification numbers, it is legitimate for them. Now, the one that wins is the one that's supposed to be employing you. So you have to make sure you're willing to work for the affiliated employer, whichever one wins the lottery. But so far, it is a legitimate thing to do. Another thing to think about as you're deciding about H-1Bs is quality control. It's very important. You don't want your H-1B petition to be kicked back because one box was not checked correctly or the filing fee was not filled out properly. And so what we hear at Miller-Mayer is that we make sure that 2 people or sometimes 3 people look at every H-1B petition before it goes out the door, because we don't want those kinds of small errors to hurt our clients in trying to win the H-1B lottery.
Oh, I've heard of cases where I think USCIS rejected a petition because it was missing a page. Probably someone just forgot when they were mailing it. And you don't want that happening.
Right. So another question that came in is, we know some students who are trying to finish their courses fast to be able to enroll in this year's H-1B lottery. Should I try, for example, to enroll in a weekend course so that by the time OPT I can apply for a 3-year extension if it's STEM OPT? I think that's actually 2 questions. One is, what if I finish up my classes fast before May, but I'm not actually going to get the diploma until May? Can I enroll in this year's H-1B lottery? Sandra, how would you answer that first question?
I mean, if you have, I hope I understood the question correctly. If you have completed everything required for that degree and you can get something from the university saying that you've basically met all the requirements for the degree, then you should be eligible to file this year.
Although many universities don't
Do that
anymore.
Yeah.
Right. So the second part is, what if I'm studying English? And that, because it's not a STEM degree, I normally would only get 1 year of OPT. If I enrolled in a weekend STEM-based course like digital media for English majors, by taking that 1 course, would I suddenly qualify for 3 years of STEM OPT because I've taken a STEM course? Hillary, you're laughing, so you get to answer that question.
Oh, it was a brave attempt at creative thinking. The answer is no. This logic does not hold, because the STEM program has to be a degree program in order to result in any OPT. So taking a course in a STEM field is not getting a degree.
Great. Another question that came in is, can I hire Miller-Mayer separately from my employer to make my application for the H-1B process? Hillary?
So this is an employer-sponsored visa category. The foreign national does not sign the petition. So certainly you can hire, and we are often hired by the employee, but the employer has to be on board, has to be willing to work with us, and some companies that have their own law firm might make an exception if an employee asks. Or we also sometimes give the employee individual advice, but the petition itself is filed by the company's lawyer.
In terms of how much that would cost the individual, we do an initial consultation because some H-1Bs are harder than others, so we don't necessarily set our price at the very beginning. So that's why we ask for an initial consultation. We've got time for 1 more question, and then we'll have to wrap it up. And the last question is, if an applicant has been selected for the lottery, how early before October 1st can they make an appointment at their home country U.S. Embassy to have the H-1B visa actually issued?
So the visa can be issued 90 days before October 1st. That means July 1st. But the visa cannot be used to enter the U.S. until 10 days before October 1st, which is September 21st. So it really doesn't behoove anyone to go out super early and get that visa issued on July 1st unless they're planning to stay out of the U.S. the entire summer.
Great. Well, with that, we've run out of our hour, but we really appreciate all of you who have listened in. As we mentioned before, we will send around these slides, including the bonus slides, to everyone who registered. This will also be on our website, so if you have other friends who failed to register but want to look at the webinar, say a week or a year from now, they can just go to our website and type in webinar as their search, and they'll be able to come up with all of our webinars. So with that, we thank you very much, and we wish you luck in this year's H-1B lottery.
Bye-bye.
Bye.